Welcome to the Law of Self-Defense. I am, of course, Attorney Andrew Branca for the Law of Self-Defense. Thank you so very much. We're at the end, folks. We're at the end of this 3-hour-plus reading of the seminal U.S. Supreme Court decision on the Second Amendment, New York State Rifle and Pistol Association v. Bruen, handed down in 2022, the 7th of 7 segments, the final segment of my reading of Bruen, and this consists of the second half of the dissent, written by Justice Stephen Breyer. Let's jump into that right now. Hey, folks, if you like this Law of Self-Defense content, and I know you do, that's why you're here, you may as well consider picking up a free copy of our best-selling book, The Law of Self-Defense Principles. It's a real physical book. It's not just a PDF download. You can check it out on Amazon, where it's 5-star rated, over 1,400 reviews, but don't buy it on Amazon. They'll charge you for the book and the shipping and handling. We only ask that you cover the cost of shipping the book to you. The book itself is free. You can get this book, learn more about it at lawofselfdefense.com/free book. Indeed, the court's application of its history-only test in this case demonstrates the very pitfalls described above. The historical evidence reveals a 700-year Anglo-American tradition of regulating the public carriage of firearms in general and concealed or concealable firearms in particular. The court spends more than half of its opinion trying to discredit this tradition, but in my view, the robust evidence of such a tradition cannot be so easily explained away. Laws regulating the public carriage of weapons existed in England as early as the 13th century, and on this continent since before the founding. Similar laws remained on the books through the ratifications of the Second and 14th Amendments through the present day. Many of these historical regulations impose significantly stricter restrictions on public carriage than New York's licensing requirements do today. Thus, even applying the court's history-only analysis, New York's law must be upheld because historical precedents from before, during, and after the founding evinces a comparable tradition of regulation. England. The right codified by the Second Amendment was inherited from our English ancestors, and some of England's earliest laws regulating the public carriage of weapons were precursors of similar American laws enacted roughly contemporaneously with the ratification of the Second Amendment. I therefore begin, as the court does, with the English ancestors of New York's laws regulating public carriage of firearms. The relevant English history begins in the late 13th and early 14th centuries, when Edward I and Edward II issued a series of orders to local sheriffs that prohibited any person from going armed. Like New York's law, these early edicts prohibited public carriage absent special governmental permission and enforced that prohibition on pain of punishment. The court seems to suggest that these early regulations are irrelevant because they were enacted during a time of turmoil, when malefactors harried the country committing assaults and murders. But it would seem to me that what the court characterizes as a right of armed self-defense would be more rather than less necessary during a time of turmoil. The court also suggests that laws that were enacted before firearms arrived in England, like these early edicts and the subsequent Statute of Northampton, are irrelevant. But why should that be? Pre-gun regulations prohibiting going armed in public illustrate an entrenched tradition of restricting public carriage of weapons. That tradition seems as likely to apply to firearms as to any other lethal weapons, particularly if we follow the court's instruction to use analogical reasoning. And indeed, as we shall shortly see, the most significant pre-firearm regulation of public carriage, the Statute of Northampton, was in fact applied to guns once they appeared in England. See Sir John Knight's case from 1686. The Statute of Northampton was enacted in 1328. By its terms, the statute made it a criminal offense to carry arms without the king's authorization. It provided that, without such authorization, no man, great nor small, of what condition soever he be, could go nor ride armed by night nor day in fairs, markets, nor in the presence of the justices or other ministers, nor in no part elsewhere, upon pain to forfeit their armor to the king, and their bodies to prison at the king's pleasure. For more than a century following its enactment, England's sheriffs were routinely reminded to strictly enforce the Statute of Northampton against those going armed without the king's permission. The court thinks that the Statute of Northampton has little bearing on the Second Amendment, in part because it was enacted more than 450 years before the ratification of the Constitution. The statute, however, remained in force for hundreds of years, well into the 18th century. It was discussed in the writings of Blackstone, Koch, and others. And several American colonies and states enacted restrictions modeled on the statute. There is thus every reason to believe that the framers of the Second Amendment would have considered the Statute of Northampton a significant chapter in the Anglo-American tradition of firearms regulation. The court also believes that by the end of the 17th century, the Statute of Northampton was understood to contain an extra-textual intent element, the intent to cause terror in others. The court relies on two sources that arguably suggest that view: a 1686 decision, Sir John Knight's case, and a 1716 treatise written by Sergeant William Hawkins. But other sources suggest that carrying arms in public was prohibited because it naturally tended to terrify the people. According to these sources, terror was the natural consequence, not an additional element, of the crime. I find this view more persuasive in large part because it is not entirely clear that the two sources the court relies on actually support the existence of an intent to terrify requirement. Start with Sir John Knight's case, which according to the court considered Knight's arrest for walking about the streets and into a church armed with guns. The court thinks that Knight's acquittal by a jury demonstrates that the Statute of Northampton only prohibited public carriage of firearms with an intent to terrify. But by now, the legal significance of Knight's acquittal is impossible to reconstruct. The primary source describing the case, the English reports, was notoriously incomplete at the time Sir John Knight's case was decided, and the facts that historians can reconstruct do not uniformly support the court's interpretation. The King's Bench required Knight to pay a surety to guarantee his future good behavior, so it may be more accurate to think of the case as having ended in a conditional pardon than acquittal. And notably, it appears that Knight based his defense on his loyalty to the crown, not a lack of intent to terrify. Similarly, the passage from the Hawkins Treatise on which the court relies states that the Statute of Northampton's prohibition on the public carriage of weapons did not apply to the wearing of arms unless it be accompanied with such circumstances as are apt to terrify the people. But Hawkins goes on to enumerate relatively narrow circumstances where this exception applied. When persons of quality wear common weapons or have their usual number of attendants with them for their ornament or defense in such places and upon such occasions in which it is common fashion to make use of them, or to persons merely wearing privy coats of mail. It would make little sense if a narrow exception for nobility were allowed to swallow the broad rule that Hawkins and other commentators of his time described elsewhere. That rule provided that there may be an affray where there is no actual violence, as where a man arms himself with dangerous and unusual weapons in such a manner as will naturally cause a terror to the people, which is strictly prohibited by the Statute of Northampton. And it provided no exception for those who attempted to excuse the wearing such armor in public by alleging that he wears it for the safety of his person from assault. In my view, that rule announces the better reading of the Statute of Northampton as a broad prohibition on the public carriage of arms and other weapons without an intent to terrify requirement or exception for self-defense. Although the Statute of Northampton is particularly significant because of its breadth, longevity, and impact on American law, it was far from the only English restriction on firearms or their carriage. Whatever right to bear arms we inherited from our English forebears, it was qualified by a robust tradition of public carriage regulations. As I have made clear, I am not a historian, but if the foregoing facts, which historians and other scholars have presented to us, are even roughly correct, it is difficult to see how the court can believe that English history fails to support legal restrictions on the public carriage of firearms. The colonies. The American colonies continued the English tradition of regulating public carriage on this side of the Atlantic. In 1686, the colony of East New Jersey passed a law providing that no person or persons shall presume privately to wear any pocket pistol, skeins, stilettos, daggers, or dirks, or other unusual or unlawful weapons within this province. East New Jersey also specifically prohibited planters from riding or going armed with sword, pistol, or dagger. Massachusetts Bay and New Hampshire followed suit in 1692 and 1771, respectively, enacting laws that, like the Statute of Northampton, provided that those who went armed offensively could be punished. It is true, as the court points out, that these laws were only enacted in 3 colonies, but that does not mean that they may be dismissed as outliers. They were successors to several centuries of comparable laws in England, and predecessors to numerous similar, in some cases materially identical, laws enacted by the states after the founding. And while it may be true that these laws only applied to dangerous and unusual weapons, that category almost certainly included guns. But the court's refusal to credit the relevance of East New Jersey's laws on this basis raises a serious question about what, short of a twin or a dead ringer, qualifies as a relevant historical analog. The founding era. The tradition of regulations restricting public carriage of firearms, inherited from England and adopted by the colonies, continued into the founding era. Virginia, for example, enacted a law in 1786 that, like the Statute of Northampton, prohibited any person from going nor riding armed by night nor by day in fairs or markets or in other places in terror of the country. And, as the court acknowledges, public carry restrictions proliferated after the Second Amendment's ratification 5 years later in 1791. Just a year after that, North Carolina enacted a law whose language was lifted from the Statute of Northampton virtually verbatim. Other states passed similar laws in late 18th and 19th centuries. The court discounts these laws primarily because they were modeled on the Statute of Northampton, which it believes prohibited only public carriage with intent to terrify. I have previously explained why I believe that preventing public terror was one reason that the Statute of Northampton prohibited public carriage, but not an element of the crime. And consistent with that understanding, American regulations modeled on the Statute of Northampton appear to have been understood to set forth a broad prohibition on public carriage of firearms without any intent to terrify requirement. The court cites 3 cases considering common law offenses, but those cases do not support the view that only public carriage in a manner likely to terrify violated American successors to the Statute of Northampton. If anything, they suggest that public carriage of firearms was not common practice. At least one of the cases the court cites, State v. Huntley, wrote that the Statute of Northampton codified a pre-existing common law offense which provided that riding or going armed with dangerous or unusual weapons is a crime against the public peace by terrifying the good people of the land. Huntley added that a gun is an unusual weapon and that no man amongst us carries it about with him as one of his everyday accoutrements, as part of his dress, and never, we trust, will the day come when any deadly weapon will be worn or wielded in our peace-loving and law-abiding state as an appendage of manly equipment. True, Huntley recognized that citizens were nonetheless at perfect liberty to carry for lawful purposes, but it specifies that those purposes were business or amusement. New York's law similarly recognizes that hunting, target shooting, and certain professional activities are proper causes justifying lawful carriage of a firearm. The other 2 cases the court cites for this point similarly offered only limited support, either because the atextual intent element the court advocates was irrelevant to the decision's result, or because the decision adopted an outlier position not reflected in the other cases cited by the court. The founding-era regulations, like the colonial and English laws on which they were modeled, thus demonstrate a long-standing tradition of broad restrictions on public carriage of firearms. The 19th century. Beginning in the 19th century, states began to innovate on the Statute of Northampton in at least 2 ways. First, many states and territories passed bans on concealed carriage or on any carriage, concealed or otherwise, of certain concealable weapons. For example, Georgia made it unlawful to carry, unless in an open manner and fully exposed to view, any pistol, except horsemen's pistols, dirk, sword and a cane, spear, bowie knife, or any other kind of knives manufactured and sold for the purpose of offense and defense. And the territory of New Mexico appears to have banned all carriage whatsoever of any class of pistols whatever, as well as bowie knives, Arkansas toothpicks, Spanish daggers, slingshots, or any other deadly weapon. These 19th century bans on concealed carriage were stricter than New York's law, for they prohibited concealed carriage with at most limited exceptions, while New York permits concealed carriage with a lawfully obtained license. Moreover, as Heller recognized and the court acknowledges, the majority of the 19th century courts to consider the question held that these types of prohibitions on carrying concealed weapons were lawful under the Second Amendment or state analogs. The court discounts this history because it says courts in 4 southern states suggested or held that a ban on concealed carriage was only lawful if open carriage or carriage of military pistols was allowed. Several of these decisions, however, emphasize states' leeway to regulate firearms carriage as necessary to protect the orderly and well-disposed citizens from the treacherous use of weapons not even designed for any purpose of public defense. And other courts upheld concealed carry restrictions without any reference to an exception allowing open carriage. So it is far from clear that the cases the court cites represent a consensus view. And of course, the court does not say whether the result in this case would be different if New York allowed open carriage by law-abiding citizens as a matter of course. The second 19th century innovation adopted in a number of states was surety laws. Massachusetts' surety law, which served as a model for laws adopted by many other states, provided that any person who went armed with a dirk, dagger, sword, pistol, or other offensive and dangerous weapon, and who lacked reasonable cause to fear an assault, could be made to pay a surety upon the complaint of any person having reasonable cause to fear an injury or breach of the peace. These laws resembled New York's licensing regime in many, though admittedly not all, relevant respects. Most notably, like New York's proper cause requirement, the surety laws conditioned public carriage in at least some circumstances on a special showing of need. The court believes that the absence of recorded cases involving surety laws means that they were rarely enforced. Of course, this may just as well show that these laws were normally followed. In any case, scholars cited by the court tell us that traditional case law research is not especially probative of the application of these restrictions because in many cases those records did not survive the passage of time or are not well indexed or digitally searchable. On the contrary, the fact that restrictions on public carry were well accepted in places like Massachusetts and were included in the relevant manuals for justices of the peace suggests that violations were enforced at the justice of peace level, but it did not result in expensive appeals that would have produced searchable case law. The surety laws and broader bans on concealed carriage enacted in the 19th century demonstrate that even relatively stringent restrictions on public carriage have long been understood to be consistent with the Second Amendment and its state equivalents. Postbellum regulation. After the Civil War, public carriage of firearms remained subject to extensive regulation. Of course, during this period, Congress provided, and commentators recognized, that firearm regulations could not be designed or enforced in a discriminatory manner. But that by now uncontroversial proposition says little about the validity of non-discriminatory restrictions on public carriage, like New York's. What is more relevant for our purposes is the fact that, in the postbellum period, states continued to enact generally applicable restrictions on public carriage, many of which were even more restrictive than their predecessors. Most notably, many states and Western territories enacted stringent regulations that prohibited any public carriage of firearms with only limited exceptions. For example, Texas made it a misdemeanor to carry in public any pistol, dirk, dagger, slingshot, sword cane, spear, brass knuckles, bowie knife, or any other kind of knife manufactured or sold for the purpose of offense or defense, absent reasonable grounds for fearing an immediate and pressing unlawful attack. Similarly, New Mexico made it unlawful for any person to carry deadly weapons, either concealed or otherwise, on or about their persons within any of the settlements of this territory. New Mexico's prohibition contained only narrow exceptions for carriage on a person's own property, for self-defense in the face of immediate danger, or with official authorization. Other states and territories adopted similar laws. When they were challenged, these laws were generally upheld. The court's principal answer to these broad prohibitions on public carriage is to discount gun control laws passed in the American West. It noted that laws enacted in the Western territories were rarely subject to judicial scrutiny. But of course, that may well mean that we can assume it's settled that these regulations were consistent with the Second Amendment. The court also reasons that laws enacted in the Western Territories applied to a relatively small portion of the population and were comparatively short-lived. But even assuming that's true, it does not mean that these laws were historical aberrations. To the contrary, bans on public carriage in the American West and elsewhere constitute just one chapter of the centuries-old tradition of comparable firearms regulations described above. The 20th century. The court disregards 20th century historical evidence. But it is worth noting that the law the court strikes down today is well over 100 years old, having been enacted in 1911 and amended to substantially its present form in 1913. That alone gives it a longer historical pedigree than at least 3 of the 4 types of firearm regulations that Heller identified as presumptively lawful. But unlike Justice Kavanaugh, I find the disconnect between Heller's treatment of laws prohibiting, for example, firearms possession by felons or the mentally ill, and the court's treatment of New York's licensing regime hard to square. The inconsistency suggests that the court today takes either an unnecessarily cramped view of the relevant historical record or a needlessly rigid approach to analogical reasoning. The historical examples of regulations similar to New York's licensing regime are legion. Closely analogous English laws were enacted beginning in the 13th century, and similar American regulations were passed during the colonial period, the founding era, the 19th century, and the 20th century. Not all of these laws were identical to New York's, but that is inevitable in an analysis that demands examination of 7 centuries of history. At a minimum, the laws I have recounted resembled New York's law, similarly restricting the right to public carry weapons and serving roughly similar purposes. That is all that the court's test, which allows and even encourages analogical reasoning, purports to require. In each instance, the court finds a reason to discount the historical evidence's persuasive force. Some of the laws New York has identified are too old, but others are too recent. Still others did not last long enough. Some applied to too few people. Some were enacted for the wrong reasons. Some may have been based on a constitutional rationale that is now impossible to identify. Some arose in historically unique circumstances, and some are not sufficiently analogous to the licensing regime at issue here. But if the examples discussed above, taken together, do not show a tradition and history of regulation that supports the validity of New York's law, what could? Sadly, I do not know the answer to that question. What is worse, the court appears to have no answer either. We are bound by Heller, insofar as Heller interpreted the Second Amendment to protect an individual right to possess a firearm for self-defense. But Heller recognized that that right was not without limits and could appropriately be subject to government regulation. Heller, therefore, does not require holding that New York's law violates the Second Amendment. In so holding, the court goes beyond Heller. It bases its decision to strike down New York's law almost exclusively on its application of what it calls historical analogical reasoning. As I have admitted above, I am not a historian, and neither is the court. But the history, as it appears to me, seems to establish a robust tradition of regulations restricting the public carriage of concealed firearms. To the extent that any uncertainty remains between the court's view of the history and mine, that uncertainty counsels against relying on history alone. In my view, it is appropriate in such circumstances to look beyond the history and engage in what the court calls means and scrutiny. Courts must be permitted to consider the state's interest in preventing gun violence, the effectiveness of the contested law in achieving that interest, the degree to which the law burdens the Second Amendment right, and, if appropriate, any less restrictive alternatives. The Second Circuit has previously done just that, and it held that New York's law does not violate the Second Amendment. It first evaluated the degree to which the law burdens the Second Amendment right to bear arms. It concluded that the law places substantial limits on the ability of law-abiding citizens to possess firearms for self-defense in public, but does not burden the right to possess a firearm in the home, where Heller said the need for defense of self, family, and property is most acute. The Second Circuit therefore determined that the law should be subject to heightened scrutiny, but not to strict scrutiny, and its attendant presumption of unconstitutionality. In applying such heightened scrutiny, the Second Court recognized that New York has substantial, indeed compelling, government interest in public safety and crime prevention. I agree. As I have demonstrated above, firearms in public present a number of dangers, ranging from mass shootings to road rage killings, and are responsible for many deaths and injuries in the United States. The Second Circuit then evaluated New York's law and concluded that it is substantially related to New York's compelling interest. To support that conclusion, the Second Circuit pointed to studies and data demonstrating that widespread access to handguns in public increases the likelihood that felonies will result in death and fundamentally alters the safety and character of public spaces. We have before us additional studies confirming that conclusion. And we have been made aware of no less restrictive but equally effective alternative. After considering all of these factors, the Second Circuit held that New York's law does not unconstitutionally burden the right to bear arms under the Second Amendment. I would affirm that holding. New York's legislature considered the empirical evidence about gun violence and adopted a reasonable licensing law to regulate the concealed carriage of handguns in order to keep the people of New York safe. The court today strikes down that law based only on the pleadings. It gives the state no opportunity to present evidence justifying its reasons for adopting the law or showing how the law actually operates in practice, and it does not so much as acknowledge these important considerations. Because I cannot agree with the court's decision to strike New York's law down without allowing for discovery or the development of any evidentiary record, without considering the state's compelling interest in preventing gun violence and protecting the safety of its citizens, and without considering the potentially deadly consequences of its decision, I respectfully dissent. Okay, folks, that's it for my reading of the U.S. Supreme Court decision of New York State Rifle and Pistol Association v. Bruen. Keep your eyes out open. We're going to be doing readings of Heller and McDonald as well. When we have everything done, I'll link it across all three of those readings. I hope you enjoyed this. I look forward to seeing you next time. And that's it, folks. We are done. We are done with our reading of New York State Rifle and Pistol Association v. Bruen. I hope you enjoyed it. For those of you who are Law of Self-Defense members, we're also going to put together entire readings of each of the three seminal U.S. Supreme Court decisions we recently covered, Heller, McDonald, and Breyer, meaning we'll put all the segments for each individual decision into its own audio file so you have each case in its entirety. But it was easier for us to distribute in the moment as chopped up segments for each decision, which is what we did. And now that we finished up Bruen, I finished up my readings, for the time being, of U.S. Supreme Court decisions affecting the Second Amendment, affirming our individual right to self-defense, both as it applies to the federal government, to the states, and the privilege to keep and bear arms outside the home for purposes of self-defense, as recognized in this decision of Bruen. Until we meet again, I remain Attorney Andrew Branca for Law of Self-Defense. Stay safe. If you like this kind of content, and I know you do, that's why you're here, you may as well consider becoming a Law of Self-Defense member. It's dirt cheap to at least try it out. You can get a 2-week trial membership for only 99 cents. Just go to lawofselfdefense.com/trial to sign up for that. In the unlikely event you don't like it and you'd like your money back, we'll give you a 200% refund. Most people, almost everyone, stays a member, and just being a standard member of Law of Self-Defense is dirt cheap. It's only about 30 cents a day, less than $10 a month to be a member of Law of Self-Defense. Get unlimited access to all our members-only content. It's the only way to have your comments and questions on live streams be addressed by me. You get a members-only podcast. Much of our content is limited, so only members can access it. Get all that and much more at lawofselfdefense.com/trial. Just try it out for 2 weeks, 99 cents, 200% money back guarantee. It's a negative risk opportunity. I hope you see you as a member real soon.